All right, we're going to go on the record. 2021 CR 2505. If could have parties announced for the record for the state.
Michael Villarreal, Michelle Hayden for the state.
For the defense.
Shannon Locke and Kim Gonzalez for OTIS TOUSSAINT.
All right, have both parties received a copy of the charge of the court?
Yes,
State
Your Honor.
has.
State, any objections?
Yes, Your Honor. The only objection we have, as previously mentioned in bench conferences concerning the charge of the court, is objecting to the mistake fact charge. And in support of our objection, may I approach the court, Your Honor?
Yes.
I'm going to provide both defense and the court a copy of Miller v. State and Vitello v. State. And I've highlighted the relevant portions for all parties. Specifically in Miller v. State, court held that a defendant's mistake of belief that his conduct was lawful is not a mistake of fact for purposes of this defense. It is my understanding of what Mr. Locke has proffered to the court and the basis of his mistake of law or request for mistake of fact jury instruction is based on the fact that Mr. TOUSSAINT received bad legal advice and therefore he acted upon that bad legal advice and then committed this offense. Further in Vitello v. State, the court held again that says, assuming the appellant's version of the facts is true, the only mistake he made was believing his actions were not unlawful. Such a belief is not a mistake of fact. Further, I thought that was important in this case, says when the defensive theory merely negates the existence of an essential element of the state's case, rather than justifying or excusing the culpable conduct, a separate instruction is not required. Here, it seems like the crux of the defensive theory is that it's the status quo and the ambiguity of it is the defense, not that he had a mistaken belief as it relates to a fact of the case. And so based on those two cases, we're objecting to the mistake of fact instruction to the jury.
All right, defense, have you seen the state's case law?
I have, Your Honor. I'd like to, may I respond?
Yes.
Okay. So I think the procedural posture of at least Vitello is important. That was the defense asking for the instruction, the trial court finding that it wasn't appropriate, and then the Court of Appeals affirming that. It wasn't that the trial court gave the instruction and then reversed. So here they're saying that it's not necessary if if you didn't give the instruction, you don't have to. So that is different than our situation where we are entitled. But we are entitled to this instruction. Mr. Rodriguez testified very clearly that he gave this advice, that he gave the advice to maintain the status quo. And if Mr. TOUSSAINT relied on that advice based on his belief that that was valid legal advice, and it wasn't, if it wasn't, then he should be entitled to this instruction.
All right, but nobody ever defined what status quo was. No witness did.
Well, so I believe many witnesses did.
No, they did not.
So yes, they said.
No, they did not.
Okay. May I respond, Your Honor? Or?
Yes.
Okay. Every witness said that the status quo was that Omari was with OTIS on January 2nd, 2020, and when the Tennessee Court of Appeals ruled, they said that Omari was with OTIS.
No one stated what they meant by status quo.
And that's one of the problems, Your Honor.
Well, no, your argument is that everyone defined status quo. They did not. No one defined what status quo meant.
But everybody said
So
that.
with regards to the case law for Vitello and Miller, what is your argument?
That we're entitled to the mistake of fact instruction. what Mr. Rodriguez testified to was that his advice was to maintain the status quo and keep Omari with you. That's what he testified to.
No, he didn't testify, maintain status quo and keep Omari with you. He just said, we're at status quo.
Which was Omari living with Otis.
And Judge, my recollection of Mr. David Rodriguez's testimony, which was hard to elicit, but I think I tried to take it step by step, specifically as it relates to the advice that he gave Mr. Toussaint on January 2nd of 2020. And I asked, what legal advice did you give him relevant to this date? And he just really was just an unresponsive answer that we're going to continue litigating. It related nothing to, and I specifically asked, did you advise him to not turn over the child to Sharita? And he said that he did not. And so I think that's a clear distinction in this case, as it relates to what defense is arguing about their entitlement to this instruction.
All right, so any other objections other than to that specific portion state?
No, Your Honor.
All right, defense, any objections?
Yes, Your Honor. So on number 3, I do think that it's important to have some limitation on there. As I have argued before, and as has happened in this trial, to my concern, and over my objections, the indictment has been constructively amended by the state's evidence. But here, constructively amended and to the prejudice of my client, because this case involves 3 different states and at least 2 different jurisdictions and testimony surrounding that. So the jury could find, for instance, that when Sharita was talking about the school and picking up and having an order that wasn't completely signed, that was an unlawful taking or retention. It happened within the 3 years, but it happened in Tennessee. And according to this court's instructions, Mr. Toussaint could be found guilty of that without any nexus to Bexar County. And so the instruction has to have some sort of limitation in it because we have such jurisdictional and wide-ranging evidence beyond this indictment, beyond what we could have had notice for based on what the indictment said. They could have very easily indicted him from, let's say November to June or March or whenever. They could have indicted him that way. They chose not to. It's their indictment, their charge, and so they should be stuck with January 2nd.
All right, that'll be denied. Any other objections?
Would the court put in that it must be in Bexar County, Texas?
And Judge, isn't that throughout the charge as it relates to specifically in the first paragraph?
Yes. So it states in the first paragraph that the incident occurred in Bexar County.
And so, Your Honor, to avoid confusion, I would ask that it would be put back also into that honor about charge.
That'll be denied. Any other objections?
Let me just take a look, Judge. A legal right to retain the custody of the child, Omari Toussaint. We'd ask that the term in Germany be removed.
What page are you on?
Page 5, or it's paragraph 5. And then I wouldn't ask that it be said back to status quo. This situation put us to status quo. So the word judgment, Your Honor, we'd ask that it be the word opinion.
No, the word judgment is going to say, because that's what it was a judgment.
But I'm just on the record asking for the word opinion.
All right, that'll be denied. Now, with regards to the issue of Germany, what is your issue with the word Germany?
The conversation took place, well, it's pretty well established that it was in Selma, Texas, that everybody was at that point. The conversation was happening on January 2nd or January 1st.
State with regards to the words Germany.
And just, I think this goes back to our ambiguity about what advice specifically Mr. Rodriguez gave Mr. Toussaint. Because my recollection is that he essentially didn't give any legal advice as it relates to January 2nd of 2020, relating to the possession of Omari. So I don't know. It's hard to respond to because I don't know what language would be appropriate, because there is no statement from my recollection in his testimony from Mr. Rodriguez concerning what specifically he told Mr. Toussaint that he relied upon that would negate his culpable mental state.
The evidence is very clear, Your Honor, that at no point was Mr. Rodriguez representing OTIS while he was in Germany. He was in Texas. He said specifically, and I think it is uncontroversial.
The judgment that's from the Court of Appeals in Tennessee at Nashville, was that the judgment, the status quo that was in place while Mr. Toussaint was in Germany?
No. So Mr. Toussaint was in Tennessee at that point. He was not in Germany. And then he hires Mr. Rodriguez while he's in Texas. Tennessee Court of Appeals did not order Mr. Toussaint back to Germany.
No, that's not my question. My question is, was the judgment from Tennessee in place while he was in Germany? That is my question. That's either a yes or no.
And Judge, timeline wise, I believe that the testimony was that at the time Mr. Rodriguez filed the domestication request on November 25th of 2019, at that point, Mr. Toussaint had been living in Texas for 6 months, which is the reason that they filed the domestication at that point.
With Omari. So
I think then it should probably say legal right to retain custody of the child Omari Toussaint. Then you will find the defendant not guilty and not put in the in Germany part. State.
Honestly, Judge, I think that if the court is inclined to give this instruction, then it should just say, told him that the express terms of the judgment of the court of Tennessee at Nashville put his custody situation to status quo. And then stopping there, because there is no testimony regarding specifically, again, what advice he meant and how he defined status quo.
All right, so you want to stop, you're requesting that then it be stopped at the word status quo?
Correct.
But are you asking to leave out then the part that says that meant that Otis Earl George Toussaint had a legal right to retain custody?
Correct, Judge, because that was not listed as part of the testimony.
Defense?
Judge, we believe just that the two words in Germany should be removed, nothing else. And Judge, to support that, an affirmative or a defensive instruction needs to be supported by evidence, and the evidence that the state elicited is essentially that phone call. And that phone call supports both this instruction and telling him that he had, and
All right, we're stopping at the word status quo. Any other objections, defense?
Your Honor, we'd ask for a mistake of law instruction. Specifically, we would ask that the court instruct the jury that if OTIS TOUSSAINT reasonably believed his conduct did not constitute a crime, or he reasonably relied on either an administrative order or a written interpretation of law contained in an opinion of record, then he should resign.
All right, that'll be denied. Any other objections?
And to support that, Your Honor, the opinion that he was relying on was the National Court of Appeals and his interpretation of that from Mr. Rodriguez.
That will be denied. And Mr. Rodriguez did never testify that he told Mr. Toussaint, this is specifically what this judgment out of the appellate court of Nashville means. The only testimony from the witness, I believe, was that it's status quo, whatever status quo means. So therefore, that will be denied. Anything else?
Your Honor, we would ask that the phrase "our law provides a defendant may testify in his own behalf," if he elects to do so, we ask that be removed.
That'll be denied.
So we would ask is that it says, if the defendant elects not to testify, that fact cannot be taken as a circumstance against him.
All right, that'll be denied.
We just say that's an improper comment on his right to remain silent. Additionally, Judge, because there was a discussion or testimony was elicited about his lack of cooperation with the investigation, we'd ask that a curative instruction be given to the jury to disregard that he had no obligation to cooperate with the investigation, and so that should not be considered.
That was testimony that was elicited by the defense. That'll be denied. Is there anything else?
And Judge, that testimony was originally elicited from the state, and then we had to clean it up as much as we could on cross.
All right, that'll be denied.
So that's why we'd ask for the curative instruction, Your Honor.
Right, that's denied. And I'm reviewing the paragraph that relates to the judgment out of the appellate court. I don't think that explains things to the jury. I think what it should say is status quo, comma, OTIS Earl George Toussaint believed that status quo meant that he could retain custody of the child, and then follow through with, then you will find the defendant not guilty. But I'm thinking just remove the part that it says to, that says in Germany. Any objections to that state?
Judge, I just think it's not congruent with the evidence, any of the evidence, and so I think it's inserting the fact into the jury's charge that doesn't exist, and so based on that, we believe that it'd be improper to put basically words even a summation of the testimony that did not ever come out and was presented to the jury.
All right, I'm going to have it as status quo. I'll just take out the part that says the, in Germany. Anything else from either side?
And Judge, if we could just, if we're gonna put that, then I think the testimony based on the phone conversation that we have, it said, when they asked, the police officers asked Mr. Rodriguez, when is they going to return the child? And he doesn't provide an answer. It appears it's indefinitely. And so that meant that Otis Earl George Toussaint had a legal right to retain custody of the child, Amari Toussaint, indefinitely.
No, I think that's something that you should say for, you can use for argument.
And just, we were asking that the situation, that the word back be removed.
I'm sorry, what?
The word back,
No, that will not be removed. Is there anything else with regards to the charge?
and so in our opinion, the word back is an improper comment on that.
All right. Is there anything else from either side?
I'm sorry, this language is just concerning for me. But if we could put something so that it's clear that
This is what it's gonna say. When you have fact to wit, it's gonna say that when his attorney, David Rodriguez, told him that the express terms of the judgment of the Court of Appeals of Tennessee at Nashville put his custody situation back to status quo, Otis Earl George Toussaint reasonably believed that status quo meant that he could retain custody of the child, Omar Toussaint.
I know this is just a semantics, but we can just put an and in front of that, and that meant, so that it's clear that the advice is both the first portion and the second portion.
Yes. So we'll put the word status quo and AND meant that. And I'm also gonna, once this is printed, I'm gonna have it printed on a different printer because it appears that some,
Some is bold.
yes, some are in
Yes.
bold, some are not. That's because, again, in the 187th, we have problem with equipment. So we're gonna get it printed on another printer. And if it needs to be printed on the printer that's in my office, we will do that.
That'd be great, Rob.
Nobody objected to that. I'm shocked.
You know, it was on the tip of my tongue and then we got it.
Were you,
I was looking at it and yes, I forgot.
Kim, were you gonna object to the printing?
I object to the fonts, Your Honor.
That
I don't like New Century School Book, but that's.
will be sustained.
Are we gonna get a new charge or just that page?
No, we're gonna get a new charge. And I have to reprint everything anyway because of the printing.
You can I'll print to the big one, because it's printed on the little printer by the clerk.
All right, thank you. You all can be seated unless you want to stretch. Sometimes it takes a long time to line the jurors up, but she'll let us know before she brings them in. I've done that before and I've been standing for like 10 minutes, so. Yes.
All right, to the jury.
There's been a big change in the seating arrangements over here. All right, everyone, please be seated. All right, ladies and gentlemen, what I'm going to read to you is what's called the charge of the court. You will receive a copy of this charge when you go back to deliberate. Brenda, are you ready? Yes. Charge of the court. Members of the jury, the defendant Otis Earl George TOUSSAINT stands charged by indictment with the offense of interference with child custody alleged to have been committed on or about the second day in January 2020 in Bexar County, Texas. The defendant has pleaded not guilty. Our law provides that a person commits the offense of interference with child custody if the person takes or retains a child younger than 18 years of age when the person knows that his taking or retention violates the express terms of a judgment or order, including a temporary order of a court disposing of the child's custody. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date in indictment, but may prove the offense, if any, to have been committed at any time prior to the presentment of the indictment, so long as said offense, if any, occurred within the 3 years of the date of the presentment of the indictment. You are further instructed that the day the indictment was presented and the day of the offense, if any occurred, shall not be computed within the 3-year limitation period. The indictment in this case was filed on March 18, 2021. Now, if you find from the evidence beyond a reasonable doubt that on or about the second day of January 2020, Otis Earl George TOUSSAINT did intentionally or knowingly take or retain Omari TOUSSAINT, a child younger than 18 years of age, knowing that the taking or retention violated the express terms of a judgment or order of a court disposing of the child's custody, to wit, 19th Judicial Circuit Court, Cole County, Missouri, or if you find from the evidence beyond a reasonable doubt that on or about the second day of January 2020, Otis Earl George TOUSSAINT did intentionally or knowingly take or retain Omari TOUSSAINT, a child younger than 18 years of age, knowing that the taking or retention violated the express terms of a judgment or order of a court disposing of a child's custody, to wit, the Court of Appeals of Tennessee at Nashville, then you will find the defendant guilty of the offense of interference with child custody as charged in the indictment. If you do not so find if you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. You are instructed that it is a defense to this prosecution that the actor through mistake formed a reasonable belief about a matter of fact if his mistaken belief negated the kind of culpability required for commission of the offense. The term reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Otis Earl George Toussaint, did engage in the alleged conduct as charged in the indictment and as instructed in paragraph 4, but you further believe or you have a reasonable doubt as to whether at the time of such alleged conduct, Otis Earl George Toussaint had through mistake formed a reasonable belief about a matter of fact, to wit, his attorney, David Rodriguez, told him that the express terms of the judgment of the Court of Appeals of Tennessee at Nashville put his custody situation back to status quo, and Otis Earl George Toussaint reasonably believed that status quo meant that he could retain custody of the child, Omari Toussaint, then you will find the defendant not guilty. But if you believe beyond a reasonable doubt that the defendant, Otis Earl George Toussaint, had not through mistake formed a reasonable belief about such matter of fact as described above, or that such belief did not negate the kind of culpability required for the commission of the offense as defined in this charge and as instructed in paragraph 4, you will find against the defendant on the defense of mistake of fact. You are instructed that if there is any testimony before you in this case regarding the defendants having committed acts of misconduct other than the offense alleged against him in the indictment in this case, you cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such acts of misconduct, if any were committed, and even then you may only consider the same in determining the motive, opportunity, intent, preparation, or plan, if any, of the defendant, and for no other purpose. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Written or recorded statements made by a witness to investigators or other officers or police reports made by officers intended by the prosecution to the defense for purposes of cross-examination are not a part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. The grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in determining whether the defendant is guilty or not guilty. All persons are presumed to be innocent, and no person may be convicted of an offense unless such element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. Do not let bias, prejudice, or sympathy play any part in your deliberations. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, or computer, the internet, or any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to communicate with anyone any information about this case or to conduct any research about this case until I accept your verdict. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But the law of the case you must receive from the court as contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact or verdict to be reached in this case. No such indication was or is intended. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as presiding juror. The form is not intended to suggest to you what your verdict should be. Your sole duty at this time is to determine whether the defendant is guilty on an indictment in this cause and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, the presiding juror shall notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and shall be submitted to the court through the bailiff. Respectfully submitted, Judge Boyd of the 187th District Court. Verdict forms are attached. State, are you ready to proceed?
Yes, Your Honor.
All right, you may proceed.
Good morning, ladies and gentlemen. Thank you for your time and attention this week. I know you've been given a lot of information. I'm just going to briefly go over the evidence and some things to keep in mind during the deliberation. Defense will present their closing argument, and then Michael will go over our case in more detail. So the evidence that you heard in Thomas' case, witness testimony, you heard from Michelle Machoto, the civil attorney that broke down the judgments and went over some of the procedural history in Sharita and Otis Toussaint's case. You heard from Sharita Lee and just the history of the custody she's had with Otis Toussaint and her son Amari Toussaint. You also heard from the Selma Police Department, Officer Carlos Lopez, Officer Stewart, Sergeant Perez, and Corporal Rodriguez. Then the other evidence that you get to consider is the physical evidence that you get back with you in the jury room. It's the two orders that are alleged in the indictment. The 19th Judicial Circuit Court, Cole County, Missouri order. It was referred to a lot as the Missouri order, the Missouri 2011 final order. The Court of Appeals of Tennessee at Nashville order from October 10th, 2019, which vacated the 2017 Tennessee order that the defendant got on his own without the knowledge of Sharita Lee. And then the 2017 vacated Tennessee order. You also have the Bexar County request to register the Missouri order, which was filed by David Rodriguez, who you heard from, on November 25th, 2019. And then there's the Bexar County counter position filed in 2021, recognizing the validity of the Missouri order. The other physical evidence that you can review, those Facebook posts, where the defendant talks about Omari's lost passport and leaving for Germany, again, without Sharita's knowledge. The audio statement with the defense attorney and Sergeant Perez that took place at the Selma Police Department. You can go back there and listen to it. And then the other evidence in the case was the defense witness, David Rodriguez, the defendant's attorney. What's not evidence, which you don't get to take back with you, police reports that officers used to refresh their memory. You heard their testimony themselves. That was just used to help them remember. You don't get a transcript of the entire testimony. If there's a specific dispute about a specific piece of testimony, then you can ask for clarification on that, but you don't get a transcript of the entire testimony. Anything that was shown to witnesses and not admitted, you don't get to consider that, and it's not what the attorneys say, meaning state and defense. So again, the elements, you have the charge in front of you, but I'm just going to touch on these. On or about January 2nd, 2020, that doesn't have to be exact, we'll go over that more in a minute. In Bexar County, Texas, OTIS TOUSSAINT intentionally or knowingly took or retained, can be either one of those. You don't have to be unanimous as to which one, intentionally or knowingly took or retained, just that you're unanimous as to one of them. Took or retained Omari TOUSSAINT knowing that the taking or retention violated the express terms of a judgment or order disposing of the child's custody. So again, with that, there's 2 paragraphs alleged in the indictments and 2 paragraphs in your charge. So before you go back there and say, well, I think he violated the Missouri order that was in place. And before you go back there and say, well, I think he was violating the Tennessee appeals order that was in place. And before you go back there and say, well, I think he was violating both of them. That's fine, as long as you unanimously think he was violating. Again, as for the other elements that have the or in there, you don't have to be unanimous as to which one, just that you're unanimous that you did those things. Okay, so regarding specific elements, on or about January 2nd, 2020, and this is in your charge, it does not have to be an exact date, but it has to be before the indictment, which was, the case was indicted in March 2021, and within 3 years of that indictment. And it does have to be in Bexar County, Texas. Now, defendant's attorney himself told you on the stand that when they registered the Missouri order here, recognizing the validity of it, and you guys can read through that order, they filed that registration in November 2019. He said that defendant had been living in Bexar County, Texas for 6 months already. So when you go back 6 months, you count back 6 months, that would have been May 2019 that they moved here in the summer. So with that said, OTIS had custody of Omari all during summer, all during the calendar school year. And there's been a lot of talk about what calendar school year means. But if you look at that Missouri order, it has a specific provision for summer. It talks about the summer months. So it makes sense that the calendar school year in that is the non-summer months. And you can go through and read that. But at any rate, defendant had been living here violating that order since May 2019. And with regard to intentionally or knowingly, you can look at defendant's past behavior in determining what his intent was. His intent's been the same for years. His intent was the same when he said he needed Omari because he had cancer, which turns out he didn't. His intent was the same when he took his child from school without the permission of his mother, got a passport without permission, under the pretense that it's lost. And his intent was the same when he moved to Texas without telling her. His intent was not to give Omari back to his mother. Now, defense will say he's relying on his attorney, but he's not relying on him. He's trying to hide behind him now. Now, the burden of this case is beyond a reasonable doubt. It's not beyond all doubt. And I ask you when you're looking at this case, what is reasonable? And whose story makes sense? Is it reasonable for the defendant to think he could just keep his child indefinitely, not letting his child see his mother for years? Is that reasonable? Does that sound legal? to anybody? Again, it's your job to judge the credibility of the witnesses and who you believed on the stand. And I ask you, when you're doing that, think about who has a motive and whose story is consistent. Now we know David Rodriguez has the interest of the defendant in stand. And he's also trying to cover himself. And what he said on the stand is different than what he says in that audio call. In the audio call, he talks about the Missouri order. And he says, New Year's Eve, New Year's Day, Otis is supposed to have custody of Omari. But if you look at that order, he's not supposed to have custody on January 2nd, not supposed to have custody on January 3rd, and not supposed to have custody during that school year, which he already did. Well, then David Rodriguez gets on the stand and he said, well, Sharita was supposed to have custody during the summer months. That's what they were going by, this order that she told you she wasn't a part of. But even if you're looking at that, Otis had custody during the summer months. He had custody during the summer months of Texas. He had custody during the fall in Texas. He had custody all that time, and he was not supposed to do that. Sharita never had him for any part of that time. She told you she didn't see him for over a year. Now, you also have an instruction in your charge about mistake of fact. When you look at that instruction, again, that belief must be reasonable. Is it reasonable for the defendant to think he could have just kept his child indefinitely? And that belief must still negate his culpability. And it doesn't negate his culpability because, again, if you look at his behavior all the time, he had that intent not to give his child back. His past behavior shows that. He didn't want to give Omari back for a long time. And again, in your charge is you must not consider any bias, sympathy, or prejudice when you're looking at this case. You can't say, well, I think he's guilty, but I feel sorry for him because he's the defendant's father. Or I think he's guilty, but I feel sorry for him because he's got a good job, so I'm going to quit him. That should play no part in your deliberations. We ask that you find the defendant guilty and give some justice to Sharita for what she went through.
All right, defense?
Thank you, Your Honor. May it please the court.
Yes.
State. Good morning. So I told you at the beginning of this case, it was an honor and a privilege to represent Otis TOUSSAINT. I'd like to tell you that again. It's been an honor and privilege. And Otis, thank you for letting me do this. Thank you for letting me stand between you and the state of Texas. And Otis has been trusting me with his representation, representing him for about a year since this indictment. And today we're asking that this case come to a close and that you acquit Mr. TOUSSAINT. Why should you acquit him? First, let me say, it is absolutely obvious here how lucky Omari is to have two parents who love him so much. There's some people who don't even have one. So first, let's start there. These are our two parents who are doing their best. And really, I would say that the judicial system has failed them by not giving them clear orders by which they could live their lives. That's what I'm telling you. It's not Otis's fault. It's not Sharita's fault. Those orders are just not clear. Does that mean that you should find Otis guilty? No. You should acquit it. Because those orders weren't clear. They just weren't. They are not clear. They're bad orders. Take a look at them. Read them. Try to figure out where and when you're supposed to exchange the child. The Tennessee Court of Appeals, they don't give those instructions. The Cole County order, it doesn't give those instructions. Those instructions are outdated, way outdated. All we have is an instruction from the Court of Appeals to say, maintain the status quo. What does that mean? Status quo was, and according to everybody who testified, from Sharita's attorney who testified first, I said, what was the status quo? What was the status quo? Where was Omari living when the National Court of Appeals rendered its opinion? He was living with Otis. Read that opinion. As the state is talking about all these things, okay, if you want to read that opinion goes into depth about those things, okay? And the attorneys who testified said that if they wanted to, they could have returned the child to mom. If they had said, look, this was a fraud. This agreed order was a fraud, as the state has alluded to. As Sharita said, if they believed that, they could have returned Omari to mom. Look for that in the order. It's not there. They could have also said, that order was a fraud. Go back to the 19th Judicial District, Cole County, Missouri. They could have said that. Look for it. Look for it in the state's exhibit. It's not there. I asked the attorney, Michelle Masudo, find it for me. She couldn't. It's not there. It doesn't say that. It's her opinion that that's what's happened, but it's not anywhere in the judgment. It's not anywhere in that opinion. Why not? Why not? Because they said, maintain the status quo until Shelby County takes over. When does Shelby County take over? Never. They start punting it back and forth between Shelby County and Bear County. So let's talk a little bit about Otis's intent. What was Otis's intent? His attorney testified that his intent was never to keep Omari away from Sharita. That was never his intent. It was not the goal of the representation. Sometimes the goal of the representation is to keep the child away from the parent. Sometimes the parent is no good. Sometimes the parent is doing active harm. Sometimes the parent is hurting the child. And your goal as the attorney is to keep the parent away. That's not this case. It's not this case. He did not have that intent. How do you know? How do you know? It's past actions, right? It's past actions. He files in November the Missouri order. Why? Does that make it effective? No. There's a process that has to be followed, a process that was completed in June. Process that has to be followed. It was not registered and validated. That is not correct. There's a process that has to be followed. Why does Otis want to follow that process? So both parents can have access to the child, so that they can go forward on a structured environment. So everybody knows when and where to exchange the child and when. Exactly. Why? Because if you don't have those clear orders, you're going to have these kinds of problems. So that was his intent. His intent was not to keep the child away from Sharita. His past actions show that by registering the order. So let's talk a little bit about the credibility of the witnesses. And first we have Sharita's attorney, Michelle Masudo. And she has an opinion that we disagree with. But I will tell you that I don't think she took the stand in line. I believe that that's her opinion, that the status quo was the 19th county, the Cole County court. Doesn't mean that that opinion is correct. Okay, that's for a judge to decide and to go through the proper channels, which Otis was trying to do. So then you had the Selma police officers. How strange was that? How strange was that? I mean, here we are at midnight on New Year's Day. Huh. Yeah, I called the cops because my car was missing. Well, is anybody hurt? No. Well, we can file a report. Next time I'm just going to say, well, this out-of-state order, man. Nobody's picking up my kid or whatever. I mean, they come out on midnight on New Year's Day. Weird. They come back at 5 a.m. At 5 a.m., January 2nd. Weird. What is going on? But then they also get a call. They get a call from Mr. Rodriguez. And Mr. Rodriguez, he gets a gold star in my book. Any attorney who is willing to return or to call police officers because The police are at the door, client's house, he gets a gold star in my book, and he tries to explain to them. He tries to explain to them that Otis is not violating the order. He's not violating the order. He says, this is very complicated. I can send you the orders. I can send them to you. But even if the Cole County judgment is the one that's ruling, and it's now in Tennessee, and it's going back and forth between Tennessee and Texas, even if it doesn't get it on January 2nd. So the state's going to talk about on or about, and that's fine. But what we're talking about is what Otis's belief was. And what legal advice did we get? And during jury selection, we asked, we said, what happens if you're in that spot where you've got all these crazy orders and you don't know what to do? Everybody said, you call your lawyer. Why? Why do you call your lawyer? Because they're the ones that know the law, that have the opinions in front of them, and they can interpret them for you. And that's what he did. And he said very clearly, maintain the status quo. You're supposed to be maintaining the status quo. What was the status quo? Her attorney says Omari was living with Otis. Our attorney says Omari was living with Otis. The Selma Police Department are showing up at Otis's door because Omari is living with Otis. Maintain the status quo. Okay. Omari's living with me indefinitely? No, that's not what he wanted. He did not want that. He wanted Sharita also to have access. That's why they filed in November that document to modify and to register the Missouri order. It just hadn't happened yet. The process wasn't complete yet. It was still happening. When is it going to happen? Up to the courts. Cole County or the Shelby County Court and the Bear County courts have to talk. When's that going to happen? I don't know. That's not going to fly. I mean, that was the Selma police officer's reaction. That's not going to fly. To the judges. We're trying to work this out. So at the end of the day, the question is, did he knowingly and intentionally violate these orders? There are 3 reasons you should find him not guilty in 3 different ways. And some of you may say, well, look, I'm presuming him innocent, and I didn't hear enough evidence. I didn't hear a clear order. I didn't hear enough evidence to find him guilty. I'm just going to presume him innocent. I'm going to find him not guilty. That's fine. Some of you may say, well, the state just didn't meet its burden. I don't think he intentionally or knowingly violated anything. That's fine. We'll find him not guilty. And then there's the mistake of fact. That when David was on the phone, midnight phone call, it was past midnight. David said, I think that was about 2 a.m. My anniversary's the next day. I'm in Ruidoso. I'm with my wife and family, my 2 kids. We're out of state. At 2 o'clock in the morning, I'm sure his whole family was thrilled about that. At 2 o'clock in the morning, I'm returning this phone call. You can hear the sleep in his voice. And man, I'll tell you that might be the most surprising thing. This attorney was calling back and saying, look, you guys are getting this wrong. Otis doesn't need to get back the kid. This is a very complicated case. Let me send you this stuff. Don't arrest him. Don't arrest him. I've had those phone calls where the FBI is outside. And guess what? As an attorney, he said, I said, do you give legal advice? Is what the clients want to hear? No. I've had those phone calls. Schlock, the FBI is outside my door. They can't come in right now. What do I have to do? They have a warrant. They say they have a warrant. Man, you got to let them in. I don't want to let them in. I can't let them in this house. You have to let them in. Have to. Not what the client wants to hear. Legal advice. Sometimes you have to do that. Here, David gave his best legal advice. He gave his best legal advice. Was it good advice or not? Even if you think that it was bad advice. Otis was relying on his advice. And remember, in jury selection, we talked about that. We talked about that. And we said, what do you do if your lawyer tells you to do something? Well, you do it. You do it. Could you imagine, Mr. Rodriguez, could you imagine that your client would get arrested for following your advice? No, no way. No way. Here we are. Here we are. And, you know, David is not Otis's current lawyer. He came in here not having represented Otis for more than 8 months. He came in here, frankly, because he cares that much about Otis, about who Otis is. And we all feel that burden. Here's this guy who's trying to do his best by his kid, do his even his best by Sharita. He's trying to do his best. And this is what happened. I told you at the beginning of this case, it was an honor and privilege to represent Otis. He is a man who has served our country. He follows orders. He follows orders, and he accepts legal advice. Some of us may know people like that. Some of us may know people like that. We're in the military, and in the military they teach you, if you have an expert, you do what the expert says, right? It just came through. Yeah. It came through a million dead Americans. A million dead Americans. We're starting things back up. This is the case they chose to bring. We're not here because we want to be here. I believe Otis did nothing wrong. Just come through this great pandemic. I'm asking you to do right by Otis. I'm taking that honor and privilege and I'm giving it to you. It's not with you. It's not with you. And I'm asking that you find him not guilty. He should be found not guilty. It's the right thing to do. Thank you.
Right, state.
Thank you, Your Honor. So like what Mr. Locke said during jury selection, this case is not about 5 Fridays of the month. This case is about a year and a half. A year and a half that Sharita was without her son, illegal without her son. A year and a half where she missed birthdays, she missed Christmas, she missed holidays, because not of her actions, but because of his actions. That's why we're here today. So, Mr. Locke talked a lot about evidence that he believes that he heard during trial. I don't know if I was at a different trial, if y'all were at a different trial, but a lot of the evidence that he says exists, if you look back and you remember, it wasn't there. And so I'll talk about something. I think there are some things that are undisputed in this case that are issues that you don't really have to resolve, because it's fair to say that both prosecution and the defense haven't contested these issues. Number one, who are the parties involved? We know who Omari is. He's the son of both Sharita Lee and Otis Toussaint. Right? We all know that he's a child under the age of 18. Uncontested that there's no evidence contrary to this, that Otis Toussaint took Omari on October 5th of 2018, and Sharita never had possession of the child until March of 2020. There's no evidence otherwise. That during that period of time, from October 15th, 2018, up until March of 2020, Sharita never had possession of Omari. There's no other evidence to show. That the Tennessee Court of Appeals order in 2019 vacated, or as even Mr. Rodriguez said on the phone call, which is in State Exhibit number 13, that recording, that order was thrown out, right? So it no longer exists, the 2017 Tennessee order. That's uncontroversial. And that prior to January 2nd of 2020, that Mr. Toussaint was living here with Omari for 6 months, at least 6 months. All of those things we know because neither one of them are contesting it, and evidence shows that. It appears that the only disagreement that the defense has with us and the state's case is what is the controlling point. There's I don't say famous, but often used statement about lawyers that when the facts are on your side, you argue the facts. when the law is on your side, you argue the law. And if neither, then you argue everything else. And that was the defensive theory of this case. How long did we spend talking about things that lay people, pretty sure you can easily figure it out? What's a calendar year? The kids in school should be with the mom. How hard is that? There's some specific dates in there, there's some not specific dates, but it doesn't mean that Sharita never gets to see her kid for a year and a half. I don't see that in the 2011 order. I don't see that in the 2019 Court of Appeals opinion. That Sharita never gets to see her kid from October 15th of 2018 up until March of 2020. So, kind of piggyback on that, when Mr. Locke is arguing that, well, the orders aren't clear. The orders aren't clear. What does that mean? That means Sharita doesn't get to see her kid? Ever? So that one provision might be a little bit ambiguous. Well, then she never gets to see her kid. We're not here because ambiguity of certain provisions, right? We're not here on those 5th Fridays. We're here for a year and a half. So, what is the state's evidence? First, you heard from Michelle Shoto. I think that she was easy to understand. Hopefully, she cleared up for you kind of how this case moved and progressed. Now, you'll notice that when she was on cross-examination, did she have any problem answering questions? I don't think so, right? She did not necessarily give the answer that he wanted, but she at least would answer them. She would at least answer them, right? And tell him what the meaning and legal consequences of certain orders were. Mr. Rodriguez, on the other hand, how hard was it for me to get just to even say, you talked on January 2nd, 2020. What date? January 2nd of 2020. And it's a phone call that he had heard twice. So that was in evidence that he heard twice prior to even testifying today, right? How hard was it to elicit any bit of information from him? Because obviously he has a goal in mind and he has a purpose to be here. And that is so that he can provide a shield for Mr. Toussaint's actions. Next thing that you heard from was the officers on the case, 4 of them. Mr. Locke talked about how it's weird. Isn't it so weird that they showed up to the house? So it's weird that the officers are doing their jobs. I don't find it weird that if I called my local police department, that somebody would show up if I asked them to show up. So does that mean that they're not telling the truth? Does that mean that the state, that evidence that they presented wasn't truthful? It doesn't make any sense, right? They had no dog in fight. They never even met Mr. Toussaint. They tried to, right? You heard from all 4 of the officers on January 1st.
Judge, I object. That's an improper comment on my client's right. That's the problem.
All right, that'll be overruled.
Thank you, Judge. March 1st, I'm sorry, January 1st, January 2nd, and January 3rd, 2020, they went out there and they tried to contact Mr. Toussaint, but were never able to. And how do we know it's Mr. Toussaint's residence? Because there's a vehicle on all 2 of those days that are registered Mr. Toussaint. Also, how do we know that? Because Mr. Toussaint's attorney is the one who reaches out to police. Police never reach out to him, right? So Mr. Rodriguez, he's not going to tell me exactly how he got that information. I don't know if he was unwilling or doesn't remember. Either way, I couldn't get that information from him about how he got hold to talk to police. Was it by phone? What was the conversation about? Why did you talk to police? I couldn't get a straight answer from him on any of those things. But regardless, he's the one who reached out to police. The only logical thing is that Mr. Toussaint passed along that information to him. Hey, police are at my house. Can you call them? Hey, please let me a voicemail. Can you call them? So we know that he was residing at that house. And then finally, our last witness, the state's last witness in this case, was Sharita Lee. Mr. Locke said that Omari is so lucky to have 2 parents alive. Is Omari really lucky that he got taken away from his mother for a year and a half and for Christmases, birthdays, Thanksgivings? He didn't spend time with his mom. Is that really a loving parent? What a loving parent would do? Just take their kid away and for a year and a half, not let them see their mother, not let them talk to their mother on the phone. I can't imagine what was going through Sharita's mind for that year and a half where she couldn't even talk to her son. Imagine that as a parent. I know many of you are. I can't imagine. I can't imagine having my nieces not be able to see for a year. I can imagine what this woman went through. And she was bold enough to come here from Tennessee and tell you about this time period, knowing that she was going to be cross-examined. And say what you want about that cross-examination, she could barely get her word in edgewise about what she wanted to tell you, what she needed to provide to the jury, so that y'all can make a determination why Mr. Toussaint is guilty. So, what did we learn from Sharita? Well, we learned, first of all, the dates, right? That Omari resigned from possession, October 15th, 2018, up until March 2020. Uncontroverted that Mr. Toussaint had a child during that period of time, and she was unable to ever get a hold of him. What do we also know? We know that OTIS is alive. We learned about this in getting a passport, about getting this order, illegal order out of 2017, and all the scheming and planning he had to do in order to get his child, take him out of school, get him a passport, and get him on a flight to Germany, take him away from his mother in that short period of time. If you look at State's Exhibit number 11, which is the receipt that he posted on his Facebook to add insult to injury, right? It's almost taunting Sharita. Look what I'm doing, I'm taking your kid away. About the date that he says he was able to pick up the passport and get his child taken away and off to Germany. We also know that the basis of the first extended visitation, that Sharita, being a good mother, knowing that it's in the child's best interest to have access to both children, agreed to an extended stay, an extended visitation with Omari, Mr. Toussaint in Germany in 2017, right? So, but the basis of that we find out is that Mr. Toussaint tells Sharita, I have cancer, I'm sick, I want him to finish the school year. Knowing that it might be serious health issues, I'm gonna let my son spend that time with his dad. And finally, the last witness that we heard from on this case was David Rodriguez. How do I say this delicately? There's a reason that I asked that you have, there's an attorney's obligation to be in court. And I don't feel that he fulfilled his obligation and testify. It was hard to get any information from him. He had convenient amnesia that it related to when I talked to people, but he can remember certain dates, right? Also, the testimony here was completely inconsistent with his phone call that you have with the Summer Police Department. Right? You never hear the words, well, it's status quo, right? That's what's controlling. He never even mentions the 2017 order, other than to say it was thrown out, it was vacated. He even agrees on that phone call, it's not a controlled order. And then all the times that the officer's like, well, when is he going to turn the kid back? He's not able to provide an answer. So to say that the defensive intent and Mr. Toussaint's intent was not to keep Omari away from his mother, Sharita Lee, is BS. Right? Because if your intent was to turn over the child and let that child see his mother, you'd be able to have an answer to that question. Right? Couldn't provide a day, a month, or even a year. Think about that. I can't even tell you in January of this year that she will have possession of the child, that she'll be able to see the child. It's never their intent. And it's convenient now that he comes in here and tells you, well, I filed the domestication of that 2011 team order, but it wasn't a valid order. Well, why would you ask for Texas to recognize it? Why would you ask Texas to make it enforceable in the state of Texas, and so that you could potentially modify it, right? And it's some complicated legalese, but it's pretty clear, even from a layperson's standpoint, I think that you're not going to ask somebody to file something that's not already in place, right? I'm asking to recognize this order that's already in place. They're just asking Texas to have jurisdiction over the case, not asking to create a new order, right? Because that's what his theory would be. I'm asking you, Texas, to create this new order and put this into effect. That doesn't make any sense. Then you file a new suit, right? And then make up your own.
This is facts, not evidence.
Gotta be overruled.
Thank you, Judge. The one good thing I was able to, or finding that needs for him, is that when this case was pending in Tennessee, like that 2019 Court of Appeals opinion says, and he testified to as well, when there was litigation in Tennessee regarding it was to modify what order? The 2011 order, right? Everybody's in agreement. It's just some now concern based on the phone call, potentially, or advice that he gave his client, that he's saying, well, I don't know. I have some ambiguity. Read it for yourself. Status quo doesn't mean you get to keep your kid indefinitely. Status quo means that you're going to go back to the orders in place, right? The only other valid order that was in place. So, Mr. Locke also talked about the mistake of fact defense. And so I want to talk about that in particular, and what you have to believe in order to consider it as a defense. And it does not apply. So these are the jury instructions that you're going to be given. So, particularly with this paragraph right here. What you have to believe is that first, David Rodriguez told them that the express terms of the judgment of the Court of Appeals of Tennessee at Nashville put his custody situation back at status quo. And you also have to believe that Otis Earl George TOUSSAINT reasonably believed that that status quo meant that he could retain the custody of the child. Retain that custody of the child indefinitely. Based on the advice, what limited advice I could get from Mr. Rodriguez about January 2nd of 2020. And again, you also have to prove that it's a reasonable belief, right? He has these orders, he knows what they are. And is it reasonable to believe that status quo means you get to keep your child indefinitely? That the mother never gets to see or have possession of the child. It's absolutely ludicrous. It's insane. It's not believable. Also, he talks about, well, maybe the advice was bad advice. And so that's why you should put him. So under Mr. Locke's theory of the case and that law, and this particular law, Mr. Rodriguez, let's say we are here for a murder case, could tell his client.
Judge, I object. That's not our argument.
All right, that'll be overruled.
He could tell his client, you can commit murder. And then we would be here for a mistake of fact because, well, the attorney said that he could commit murder and he murdered him. So I guess he's not guilty. It's ridiculous that bad advice equals his ability to rely upon it and hide behind and be accountable for the bad. That's ridiculous. There's only one true verdict in this case, and all of the evidence points to it. And that is Mr. TOUSSAINT is guilty of this offense. He's guilty of keeping Sharita away from Amari for a year and a half. We're asked that you return, you deliberate, you consider all the facts. And I think all the facts lead you to one true, correct verdict. And that is the defendant is guilty. Thank you.
All right, ladies and gentlemen, the jury, I told you I will let you know when you're allowed to deliberate. So I'm going to ask that the two alternates, who are Stephanie Torres and Joe Petkin, John Petkin, hopefully I got that last name right. All right, thank you. If you all can remain behind, and if the rest of you will follow Deputy Laura, please. Everyone, please rise to the jury.